Hello everyone, welcome to Let's Crack UPSC CSE English. In our today's session, for Prelims 2021 Crash Course Inspire, we'll see Judicial Review. Yes friends, so in today's session, we'll learn about Judicial Review. It's my pleasure to welcome you all on Unacademy, India's largest learning platform, where you will get unlimited access for live and recorded classes along with structured courses and live tests. Yes friends, it's me Rushikesh Inamdar guiding UPSC aspirants from last 8 years, and you can follow me on Unacademy. Yes, and you can join our Telegram group using this link. So friends, we have mega subscription offer where you will get the subscription of 1 year valid till prelims 2022. Means if you will subscribe Unacademy subscription for 1 year, you will get guaranteed validity of that subscription till next prelims, that is 2022. And those aspirants are looking for 2-year subscription, they will get validity till prelims 2023. So do not forget to subscribe 1 year or 2-year plans as per your convenience using referral code RBI Live, and this offer is valid till April 28. Yes friends. So those aspirants are looking for paid courses. We have plus and iconic courses available on our platform. Here also you will get 10% discount after using a referral code RBI Live. Yes friends. For the optional subject as well, you will get 10% discount after using referral code RBI Live. Yes. Now this is our combo subscription for general studies and optional subjects, where you can opt for 1 year, 2-year or 3-year course duration for your general studies and optional preparation. Here also you will get 10% discount after using referral code RBI Live. Why I'm suggesting you to use referral code? You will get discount on your fees, along with I will guide you throughout your journey for civil services. Yes, those aspirants are preparing their or pursuing their graduation, they can opt for our iconic subscription. And also those aspirants are planning to start their preparation for civil services after their 12th examination, they can go with our iconic subscription. Yes friends, in iconic subscription, you will get all the features of our plus courses, along with additionally you will get personal guidance, expert guidelines, study planner, and all features. Yes. Do not forget to enroll yourself for our free test series. So just you have to use referral code or use code RBI Live to unlock these free tests. Yes, we will cover complete general studies and current affairs. So friends, you can join this free test series for all aspirants on our platform. Yes, these are the new batches we are going to conduct for UPSC CSE. So we have batches for 1-year batch, 2-year batches, NCRT batches, and prelims targeted batches. Yes. So as per convenience, you can join these batches. And friends, do not forget to enroll yourself for Unacademy Combat. Yes, Unacademy conducting combat on every Sunday in the morning 11 a.m. And now this combat is available in Hindi medium also, which means now we have English and Hindi medium for Unacademy Combat. Yes, this is one of the India's biggest free scholarship test for UPSC CSE aspirants. So hurry up and enroll yourself using code RBI Life for Unacademy Combat. Yes. Now we'll start today's topic, judicial review. Yes, friends, as we have started polity in our Inspire crash course, where we have covered recently, that is parliamentary forum. Right now, today will and after that we have covered Supreme Court. Now we'll see the judicial review. What is mean by judicial review and all the relevant information which will cover judicial review topic. So let's move. So judicial review. What is mean by judicial review? Yes, friends. So judicial review means is the power of judiciary to review any act or order of legislative and executive wings and to pronounce upon the constitutional validity when challenged by the affected person. Yes. So the judicial review is the power of judiciary to review any act or order of legislative and executive wings and to pronounce upon the constitutional validity when challenged by the affected person. Now we'll see the details. So the doctrine of judicial review originated and developed in the United States of America. Yes, it was propounded for the first time in the famous case of Marbury versus Madison 1803 by John Marshall, the then Chief Justice of the American Supreme Court. Yes. So in India, on the other hand, the Constitution itself confers the power of judicial review on the judiciary, both the Supreme Court as well as High Court. Yes. So remember guys, in India, the Constitution itself confers the power of judicial review on the judiciary. Yes. So further, the Supreme Court has declared the power of judicial review as a basic feature of the Constitution and or an element of the basic structure of the Constitution. So the power of judicial review cannot be curtailed or excluded even by a constitutional amendment. Yes. So just note down the point. So the power of judicial review cannot be curtailed or excluded even by a constitutional amendment. Yes. Now after that we'll see the meaning of judicial review. Yes, friends. So judicial review is the power of the judiciary to examine the constitutionality of legislative enactments and executive orders of both the central and state governments. Yes. So judicial review is the power of the judiciary to examine the constitutionality of legislative enactments and executive orders of both the central and state governments. So on examination, if they are found to be violative of the Constitution, they can be declared as illegal, unconstitutional and invalid by the judiciary. Yes. So consequently, they cannot be enforced by the government. Yes. So Justice Syed Shah Mohammad Qadri has classified the judicial review into the three categories. First, judicial review of constitutional amendments. Second, judicial review of legislative of the parliament and state legislatures and subordinate legislatures. Judicial review of administrative action of the union and state and authorities under the state. Yes. So Justice Syed Shah Muhammad Qadri has classified the judicial review into review of constitutional amendment, judicial review of legislation of the parliament and state legislatures and subordinate legislations, judicial review of administrative action of the union and state and authorities under the state. Yes. So the Supreme Court used the power of judicial review in various cases. Yes, like the Golatnath case 1967, second, the bank nationalization case 1970, the Privy Purses abolition case 1971, then one of the famous case Keshwanand Bharti case 1973, Minerva Mills case 1980, and so on. Yes. So in 2015, the Supreme Court declared both the 99th Constitutional Amendment 2014 and the National Judicial Appointment Commission NJSA Act 2014 as unconstitutional and null and void. Yes, in 2015, the Supreme Court declared both the 99th Constitutional Amendment 2014 and the National Judicial Appointments Commission Act 2014 as unconstitutional and null and void. Yes, these are the recent judicial review by the Supreme Court. Yes, now we'll see the importance of judicial review. Yes, so judicial review is needed for the following reasons, like yes, to uphold the principle of the supremacy of the Constitution, to maintain federal equilibrium, the balance between the center and the states, to protect the fundamental rights of the citizens. Yes, so in a number of cases, the Supreme Court has pointed out the significance of the power of judicial review in our country. So, the importance of judicial review to uphold the principle of the supremacy of the Constitution, to maintain federal equilibrium, and to protect the fundamental rights of the citizens. Yes. Now we'll see some observations made by Supreme Court. Yes. Now we'll see. In India, it is constitution that is supreme and that a statute law to be valid, yes, must be in conformity with the constitutional requirements, and it is for the judiciary to decide it whether any enactment is constitutional or not. Yes, this is observation made by Supreme Court by Chief Justice Kania in A.K. Gopalan versus State of Madras 1950 case. Then next observation now by Chief Justice Patanjali Shastri in State of Madras versus V.G. Rao case 1952, where he observed that or stated our constitution contains express provisions for judicial review of legislation as to its conformity with the constitution, and this is especially true as regard the fundamental rights to which the court has been assigned the role of sentinel on the queue. Yes. So our constitution contains express provisions for judicial review of legislation as to its conformity with the constitution. Now, in the next case, where Justice Khanna in Keshwanand Bharti versus State of Kerala case 1973. He stated that as long as some fundamental rights exist and are a part of the Constitution, the power of judicial review has also to be exercised with a view to see that the guarantees afforded by these rights are not contravened. Yes, contravened. Yes, so some fundamental rights exist and are a part of the Constitution. Yes. Then, in the next case, observation by Chief Justice Chandrachud in Minerva Mills versus Union of India case 1980. So, it is the function of the judges may their duty to pronounce upon the validity of laws. If courts are totally deprived of that power, the fundamental rights conferred on the people will become a mere adornment because rights without remedies are as reed in water. A controlled constitution will then become uncontrolled. Yes, these are the observations by Supreme Court in various cases. So next case is L. Chandrakumar versus Union of India, case 1997, where Chief Justice Ahmadi observed that or stated the judges of the Supreme Court have been entrusted with the task of upholding the Constitution and to this end have been conferred the power to interpret it. It is they who have to ensure that the balance of power envisaged by the Constitution is maintained and that the legislature and the executive do not. So, in the discharge of their functions, transgress constitutional limitations. Yes. Then, in next case, that is S.S. Vola versus B.D. Sharma in 1997, Justice Ramaswamy stated that the founding fathers very wisely therefore incorporated the Constitution itself, the provisions of judicial review, so as to maintain the balance of federalism, to protect the fundamental rights and fundamental freedoms guaranteed to the citizens, and to afford a useful weapon for availability, availment, and enjoyment of equality, liberty, and fundamental freedoms, and to help to create a healthy nationalism. So, the function of judicial review is a part of the constitutional interpretation itself. So, it adjusted the Constitution to meet new conditions and needs of the time. Yes. So, now friends will see how this constitutional references or provisions for judicial review. Yes. Now we'll see constitutional provisions for judicial review. So now just remember that through the phrase judicial review has nowhere been used in the Constitution. So the provision of several articles, yes, the provisions of several articles explicitly confer the power of judicial review on the Supreme Court and the High Courts. Yes, the provisions are like in Article 13, which says that all laws that are inconsistent with or in derogation of the fundamental rights shall be null and void. Yes. Then, Article 32 of our Indian Constitution, which guarantees the right to move to the Supreme Court for the enforcement of the fundamental rights and empowers the Supreme Court to issue directions or orders or reads for the purpose. Yes. Now, Article 32, which guarantees the right to move the Supreme Court for the enforcement of the fundamental rights and empowers the Supreme Court to issue directions or orders or writs for that purpose. Yes. Then Article 131 of our Indian Constitution, which provides for the original jurisdiction of the Supreme Court in center-state and interstate disputes. Article 132 provides for the appellate jurisdiction of the Supreme Court in constitutional cases. Yes. Article 133, which provides for the appellate jurisdiction of the Supreme Court in civil cases. Article 134, which provides for the appellate jurisdiction of the Supreme Court in criminal cases. Article 134A deals with the certificate for appeal to the Supreme Court from the High Courts. Yes. So Article 34A was added by the 44th Constitutional Amendment Act 1978. So where the Article 134A deals with the certificate for appeal to the Supreme Court from the High Courts. Yes. Article 135 empowers the Supreme Court to exercise the jurisdiction and powers of the Federal Court under any pre-constitutional law. Yes. Article 136, which authorizes the Supreme Court to grant special leave to appeal from any court or tribunal. Yes. Which except military tribunal or court martial. Yes. Then Article 143 of our Constitution, which authorizes the President to seek the opinion of the Supreme Court on any question of law or fact and on any pre-constitution legal matters. Yes. Article 226, which empowers the High Courts to issue directions or orders or writs for the enforcement of the fundamental rights and for any other purpose. Yes. Article 227 vests in the High Courts the power of superintendence over all courts and tribunals within their respective territorial jurisdiction. Yes. So Article 227, which vests in the High Courts the power of superintendence over all courts and tribunals within their respective territorial jurisdictions. Article 245 deals with the territorial extent of laws made by Parliament and by the legislature of states. Yes. Article 246. 246 deals with the subject matter of laws made by Parliament and by the legislature of states. Articles 251 and 254, which provide that in case of a conflict between the central law and state law, the central law prevails over the state law and the state law shall be void. Yes. Article 251 and 254, which provide this provision. And Article 372, which deals with the continuous in force of the pre-constitutional laws. So these are the articles which explicitly confer the power of judicial review on Supreme Court and the High Courts? Yes, Article 13, Article 32, Article 131, Article 132, Article 133, Article 134, Article 134A, Article 135, Article 136, Article 143, Article 226, 227 and 245. Yes, Article 246, Article 251, 254 and Article 372. Yes, so these are the articles which talked about the judicial review in our country. Now we'll see the scope of judicial review. Yes, the constitutional validity of legislative enactment or an executive order can be challenged in the Supreme Court or in the High Courts on the following grounds. Yes. So the constitutional validity of a legislative enactment or an executive order can be challenged in the Supreme Court or in the High Courts on the following three grounds. Like, it infringes the fundamental rights part 3. Yes, it is outside the competence of the authority which has framed it, and it is repugnant to the constitutional provisions. Yes, so the constitutional validity of legislative enactment or an executive order can be challenged in the Supreme Court or in the High Courts on the grounds like when this legislative enactment or an executive order infringes the fundamental rights part 3, when it is outside the competence of the authority which has framed it, and it is repugnant to the constitutional provisions. Yes, so from the above, it is clear that the scope of judicial review in India is narrower than what exists in the US, though the American Constitution does not explicitly mention the concept of judicial review in any of its provisions. Yes, so this is because the American Constitution provides for due process of law. Against that, the procedure established by law, which is contained in the Constitution. So the difference between the two is the due process is law given wide scope. So the due process of law gives wide scope to the Supreme Court to grant protection to the rights of its citizens. It can declare laws violative of these rights void not only on substantive grounds of being unlawful, but also on procedural grounds of being unreasonable. Yes, as Supreme Court while determining the constitutionality of law, however, examines only the substantive question, that is, whether the law is within the powers of the authority concerned or not. It is not expected to go into the question of its reasonableness, suitability, or policy implications. Yes, the exercise of wide power of judicial review by the American Supreme Court in the name of due process of law clause has made the critics to describe it as a third chamber of the legislature, a super legislature, the arbiter of social policy and so on. Yes. So This American principle of judicial supremacy is also recognized in our constitutional system, but to a limited extent. So, there are many limitations, or we can say, nor do we fully follow the British principle of parliamentary supremacy, and there are many limitations on the sovereignty of parliament in our country, like the written character of the constitution, the federalism with division of powers, the fundamental rights and the judicial review. Yes, in effect, what exists in India is synthesis of both. Yes, that is the American principle of judicial supremacy and the British principle of parliamentary supremacy. Yes. Now, after the scope of judicial review, we'll see the judicial review of the ninth schedule. Yes, so Article 31B, which says the acts and regulations included in the ninth schedule from being challenged and invalidated on the ground of contravention of any of the fundamental rights. Yes, Article 31B, along with the ninth schedule, was added by the first Constitutional Amendment Act of 1951. Yes, so originally in 1951, the ninth schedule contained only 13 acts and regulations, but at present but in 2016 the number is 282. So the last entry number 282, the actual total number is 282, and this is because the three entries like 87, 92 and 130 have been deleted, and one entry is numbered as 257A. Yes, so Article 31B along with the ninth schedule was added by the first Constitutional Amendment Act 1950. So of these, the acts and regulations of the state legislature deal with land reforms and abolition of the zamindari system. Yes, zamindari system, that of the parliament deal with other matters. Yes, the acts and regulations of the state legislature deal with land reforms and abolition of zamindari system, and that of the parliament deal with other matters. Yes, so however, in significant judgment delivered in IR Colo case 2017, the Supreme Court ruled that there could not be any blanket immunity from judicial review of laws included in the ninth schedule. Yes, the court held that judicial review is a basic feature of the Constitution and it could not be taken away by putting a law under the ninth schedule. Yes, it said that the laws placed under the ninth schedule after April 24, yes, 1973 are open to challenge in court if they violated fundamental rights, which guaranteed under the Article 14, 15, 19 and 21 or the basic structure of the Constitution. Yes, it was on April 24, 1973 that the Supreme Court first propounded the doctrine of basic structure or basic features of the Constitution in its landmark verdict in the Keshwanand Bharati case. Yes. So, while delivering the above judgment, the Supreme Court made the following conclusions. Yes, first, so a law that abrogates or breaches rights guaranteed by Part 3 of the Constitution may violate the basic structure doctrine or it may not. So if former is the consequence of law, whether by an amendment of any article of the Part 3 or by an insertion in the ninth schedule, such law will have to be invalidated in the exercise of judicial review power of the court. Yes, so the constitutional validity of the ninth schedule laws on the touchstone of basic structure, yes, basic structure doctrine can be adjured by applying the direct impact and effect test. So that is rights test, which means the form of an amendment is not the relevant factor, but the consequence thereof would be the determinative factor. Yes. Then, second, the majority judgment in the Keshwanand Bharati case, read with Indira Gandhi case requires the validity of each new constitutional amendment to be judged on its own merits. Yes, the actual effect and impact of the law on the rights guaranteed under Part 3 has to be taken into account for determining whether or not it destroyed basic structure. Yes, the impact test would determine the validity of the challenge. Yes. Third, all amendments to the Constitution made on or after 24th April 1973, by which the ninth schedule is amended by inclusion of various laws therein, shall have to be tested on the touchstone of the basic or essential features of the Constitution as reflected in Article 21. Yes, read with Article 14 and Article 19 and the principles underlying them. Yes. So to put it differently, even though an act is put in the ninth schedule by a constitutional amendment, its provisions would be open to attack on the ground that they destroyed or damaged the basic structure if the fundamental right or rights taken away or abrogated pertains or pertain to the basic structure. Yes. So, justification for conferring protection. Yes. So, fourth is justification for conferring protection, not blanket protection. So, on the laws included in the ninth schedule by constitutional amendments shall be matter of constitutional adjudication by examining the nature and extent of infraction of a fundamental right by a statute, yes, sought to be constitutionally protected, yes, and on the touchstone of the basic structure doctrine as reflected in Article 21. Read with Articles 14-19 by application of the rights test and the essence of the right. Yes, the essence of the right test, taking the synoptic view of the articles in Part 3 as held in the Indira Gandhi case. So applying the above test to the ninth schedule laws, if the infraction affects the basic structure, then such law or laws will not get the protection of the ninth schedule. And when the triangle of Article 21 read with Article 14 and Article 19 is sought to be eliminated, not only the essence of the right test, but also the rights test has to apply. Yes, there is also a difference between the rights test and the essence of the right tests. So both from part of application of the basic structure doctrine. So friends, when in a controlled constitution conferring limited power of amendment, an entire chapter is made inapplicable, the essence of the right test. Yes, essence of the right test as applied in Nagaraj case will have no applicable. Yes, no applicability. So, in such a situation, to judge the validity of the law, it is the rights test which is more appropriate. Then, if the validity of any ninth schedule, yes, the validity of any ninth schedule law has already been upheld by this court, it would not be open to challenge such law again on principles declared by this judgment. Yes, if a law held to be violative of any rights in Part 3 is subsequently incorporated in the ninth schedule, yes, after 24th April 1973, such a violation infraction shall be open to challenge to the ground that it destroys or damages the basic structure as indicated in Article 21, which read with the Articles 14 and 19 and the principle underlying them. So, action taken and transaction finalized as a result of impingent acts shall not be open to challenge. The number of acts and regulations included in the ninth schedule before and after April 24, 1973 are mentioned. Yes, we'll discuss in the table how the number of acts and regulations included in the ninth schedule before and after 24th April 1973. Yes. So, now we'll see. So, first included before 24th April 1973. So, First Amendment 1951, where number of acts and regulations included in the ninth schedule, that is 13, that is 1 to 13. Fourth Amendment 1955, that is 7 number of acts like 14 to 20. In 7th Amendment Act 1964, 44 number of acts, that is 21 to 64. 29th Amendment Act 1972, that is 2 number of acts from 65 and 66. Now we'll see the included after 24th April 1973, where 34th Amendment Act 1974, where 20 acts, that is 67 to 86, included in the ninth schedule. 39th Amendment 1975, where 38 acts, 87 to 124, included in the ninth schedule. Then 40th Amendment 1976, there are 64 acts, 125 to 188. 47th Amendment 1984, yes, 14 acts from 189 to 202. Then 66th Amendment 1990, where 55 acts, that is 203 to 257. 76th Amendment 1994, where 1 act, that is 257A, was included in the ninth schedule. 78th Amendment, that is 1995, where 27 acts, 258 to 284, included in the ninth schedule. So these are the number of acts and regulations included in the ninth schedule. Yes, so here just remember that entries 87, 92 and 130 have been omitted by the 44th Constitutional Amendment Act 1978. Yes. Now, in final summary, where we'll see the difference between like judicial restraint versus judicial activism. So, judicial restraint, where judges should look to the original intent of the Constitution, and in activism, judges should look beyond the original intent of the framers. In judicial restraint, judges should look at the intent of the legislature that wrote the law. Whereas in judicial activism, judges should living constitution changes over time. Yes. In restraint, respectful of precedents, whereas in activism, judges should active action necessary and appropriate at times. In restraint, judges should argue that changes to the constitution can only be made through the amendment process, whereas in judicial activism, judges should say or the can be activism can be involved in interpreting and enlarging laws. Yes. So this is the judicial restraint versus judicial activism. So friends, in today's session, we have learned about judicial review. So where we have covered what is meant by judicial review. So just remember that judicial review is the power of judiciary to review any act, order of legislative and executive wings and to pronounce upon the constitutional validity when challenged by the affected person. Yes. So basically this doctrine of judicial review originated and developed in the USA. Yes. Then we have covered meaning of judicial review. So is the power of the judiciary to examine the constitutionality of legislative enactments and executive orders of both the central and state governments. So judicial review classified into the three categories, where judicial review of constitutional amendments, judicial review of legislation of the parliament and state legislature and subordinate legislations, judicial review of administrative action of the union and state and authorities under the state. Yes, so these are the classification of judicial review. By category wise. Yes, this is the category wise. Now, where we have covered or discussed, the Supreme Court used the power of judicial review in various cases. For example, the Golaknath case 1967, Bank Nationalization case 1970, Privy Purse Abolition case 1971, Keshwanand Bhati case 1973, Minerva Mills case 1980, and so on. Then we have covered the importance of judicial review to uphold the principle of the supremacy of the Constitution, to maintain federal equilibrium, to protect the fundamental rights of the citizens. Yes, then we have covered few statements in the various cases of judicial review by the Supreme Court judges. Then we have covered the constitutional provision for judicial review, where the phrase judicial review has nowhere been used in the Constitution, but the provision of several articles explicitly confer the power of judicial review on the Supreme Court and the High Courts. So where Article 13, Article 32, Article 131, Article 132, Article 133, 134, Article 134A, Article 135, Article 136, Article 143, Article 226, Article 227 and Article 245, which talked about the judicial review. Yes, Article 246, Article 251, 254 and Article 372, which collectively talked about the judicial review. Then we have covered scope of judicial review. Yes, so the constitutional validity of a legislative enactment or an executive order can be challenged in the Supreme Court or in the High Courts on the three grounds, like if that order infringes the Fundamental Rights Part 3, it is outside the competence of the authority which has framed it. Yes, it is repugnant to the constitutional provisions. Yes, so this is the scope of judicial review. Yes, then we have covered judicial review of the 9th schedule. Yes, we have studied about these provisions, and then we have covered number of acts and regulations included in the 9th schedule through one table. Yes friends, so that's it for today's session of judicial review. So friends, see you in the next session with new topic of Indian polity. Till the time you can revise what we have covered in this Inspire course. Do not forget to join our Telegram group and also use referral code RBI Live to get 10% discount. Yes friends, please like, share and subscribe the videos of Unacademy. So keep studying, keep revising. Yes, we will help you to achieve your goal. Keep studying, keep learning. All the best. Thank you.